Which judicial pronouncement of Queen Bench of England has dealt with the concept of general offer? Carlyle versus Carbolic Smoke Ball Company. Union of India versus Maddala Tithaya is the illustration where tender was in the form of standing offer. Which one of the famous cases is related with the general offer? Carlyle versus Carbolic Smoke Ball Company. The case of Mohiri versus Bibi versus Dharmodas Ghosh has laid down that India in India a minor's contract is void ab initio, in which case it was held that the contract through telephone is concluded at a place where acceptance is heard. Bhagwan Das, Govardhan Das Keda versus Mrs. Girdhari Lal Purushottam Das and Company, 1966. In which one of the following is a leading case of point of communication of offer? Lalman Shukla versus Gauri Dutt. In Bhagwan Das Govardhan Kedia versus Girdhali Lal Purushottam Das and Company, it was laid down that Section 4 does not imply that contract is made quo the proposer at one place or quo the acceptor at another place. Mohiri Bibi versus Dharmodas Ghosh is a case relating to minor's contract. In case Mohiri Bibi versus Dharmodas Ghosh is based on which provision of Indian Contract Act 1872, Section 11, which decision has laid down the principle that contract by minor is void ab initio? Mohiri Bibi versus Dharmodas Ghosh. In the case of Nash versus Inman, the issue was minor's liability. The case of Hochschild versus De La Tour deals with anticipatory breach of contract. The fact of Griffin versus Barry Mayer would attract Section 20 as fact of Keller versus Henry attract Section 56 of Indian Contract Act 1872. Which one of the following cases is related to doctrine of frustration? Keller versus Henry. The case of Frost versus 9 1872 is related to anticipatory breach of contract. Which one of the following cases is related to doctrine of frustration? Satyabrat Ghosh versus Magni Ram. The first case on the doctrine of frustration as decided by Supreme Court of India is Satyabrat Ghosh versus Magni Ram. Satyabrat Ghosh versus Magni Ram, 1954, Supreme Court. The case is on frustration. Doctrine of unjust enrichment was laid down by Supreme Court in which one of the following case? Muftalal Industry Limited versus Union of India. The principle of assessment of damage for the breach is given in Handley versus Wexendale. Handley versus Wexendale is a leading case on remoteness of damage. The case of Nash versus Inman, 1908, related to necessary. Carlyle versus Carbolic Smoke Ball Company, 1892. The court ruled an offer need not to be made to be ascertained person. Carlyle versus Carbolic Smoke Ball Company defined wagering agreement was given in Justice Hawkins. Which one of the following cases related to cross offer? Teen versus Hoffman and Company. For the acceptance of mere mental resolve to accept would not be sufficient. There must be some external manifestation in the intent by speech in writing and other act. It was held by Supreme Court in Bhagwan Das versus Girdhari Lal and Company. The rule laid down by Adams versus Lindsay was approved by the House of Lords in the case of Dunlop versus Higgins. A contract over telephone became complete at the place where acceptance is heard, in which case it has been held. Bhagwan Das versus Girdhari Lal. Concept that say unfair and unconscionable contract or clause should not be enforced, known as Cuppa in contrahendo. The case of general offer, there is no need to communicate the acceptance if it required by proposer. This has been held in the case of Carlyle versus Carbolic Smokeball Company. In the following case, which case is related to general offer? Lalman Sukra versus Gauri Dutt, Carlyle versus Carbolic Smokeball Company. Following case is a promissory estoppel. Kedarnath versus Gauri Mohammed, Delhi Cotton and General Mill Limited versus Union of India. Which one of the following is not correctly matched? Public policy Handel versus Wexendale is not correctly matched. Coercion, Chikama Ami Raju versus Chikama Seherma. Liquidated damage, Dunlop Pneumatic Tire Company versus New Garage and Motor Company. Impossibility of performance, Alopi Prasad versus Sun. Alopi Prasad and Son versus Union of India. Which one is a precedent is related to doctrine of frustration? Satyabrat Ghosh versus Mangni Ram Boncure. In the case of M.G. George versus M.G. George 1882, the wife withdraws his complaints and the husband enter into agreement with her on the condition that if she withdraw her complaint, the refrain will publish his credit, he will pay her allowances. Parties had the intention to have binding contract between them. General offer to the world at large do not make it necessary on the part of acceptor to communicate his acceptance. This is well explained in the case of Carlyle versus Carbolic Smokeball Company. The value consideration in the sense of law may be consist either in some a valuable consideration in the sense of the law may consist either in some right or interest or the benefit acquiring to the one party on some forbearance, determinants, loss, responsibility given, suffered or undertaken by other is well explained in the case of Curie versus Misha. Which one of the following pair is correctly matched? Satyabrat Ghosh versus Mangni Ram, frustration of contract. In Khemchand versus Badam, in the context of public policy relating to contract, it was decided that help given by the promised to dance girl is not tainted with the immorality. Promissory estoppel against government agencies decided in Delhi Cloth and General Mills Limited versus Union of India 1987. In Jyotindra Bhattacharya ji versus Mrs. Sona Balon Boda, it was held that the onus of proving unsoundness of mind of a person always rests upon the person who alleges that of the mind of another person. Doctrine of frustration was laid down in the first time in the case of Taylor versus Cadwell. Consideration means reasonable, equivalent, and valuable benefit passing on the transferor to transferee. Similarly, when the word consideration was qualified by the word adequate, it make the consideration strong, so make sufficient to value have regarding to fact, circumstances, the necessity of the case. Above principle was laid down in Sonia Bhatia versus State of UP. An offer need not to be made to all of the world which is stipend to the contract. When anybody comes forward and perform the condition, it is an offer to become liable to anyone who, before it is retracted, perform the condition. And although the offer is made to the world, the contract is made with the limited portion of the public who came forward to perform the condition on the faith of advertisement. The above attribute is to be Bolin LJ in Carlyle versus Carbolic Smoke Ball Company. In which one of the following cases enshrine the present position of doctrine of public policy in India? Gerulal Pakha versus Maldev Das. Consider the following statement and give the correct answer with the help of code given below. The case of Mohidi Vishwi versus Dharmodas Ghosh is the decision of Privy Council regarding the voidness of minor agreement. Handley versus Baxendale is the leading case on remoteness of damage. Moss versus McCafflan is a prominent example of theory of unjust enrichment as propounded by Lord Mansfield. According to the theory, the demand of justice and equity is to prevent the unjust enrichment of one person at the cost of another. Sinclair versus Borogum has propounded the theory of implied in fact contract to elaborate the nature of the quasi-contract. State of West Bengal versus B.K. Mondal and Son 1962 is an interpretation of which section of Indian Contract Act 70. The principle contained under section 73 of Indian Contract Act is based on Handel versus Baxendale. Mohidi Bibi versus Dharmodas Ghosh was finally decided by Privy Council. Nature of wagering agreement was explained in Carlyle versus Carbolic Smoke Ball Company. In which one of the following cases it was held that contract through telephone is concluded at a place where acceptance was heard? Bhagwan Das versus Girdhari Lal. The doctrine of promissory estoppel was used by Denninger to uphold the promise of the creditor to accept a smaller sum of discharge in large sum if such a promise is to attract upon the promise, notwithstanding the absence of consideration. Identify the relevant case in which doctrine was so developed. Denninger. Central Inland Transport Corporation versus Mumbai Port. Section 4 of Indian Contract Act 1872 does not imply that contract is made in made quo, the proposer at one place and quo, the acceptor at another place. The principle of privity of contract was held not applicable in the action for the tort in Asway versus White 1703. Section 73 of Indian Contract Act incorporates rule from which one of the following case? Handel versus Baxendale. When the contract is made on the telephone, it becomes complete at one place where the acceptance is heard. In which one of the following cases so heard? Bhagwan Das versus Girdhari Lal. In which case the following doctrine of the frustration is recognized in India? Satyavrat Ghosh versus Mankani Ram and Company. In which case it was held that state government was in the position of the bailee in the relation of goods seized by the officer and was therefore bound to take reasonable care of the seized good. State of Bombay versus Menon Muhammad Haji Hussain. Fraud was defined as well-known English case Derek versus Prick. The case of Foster versus De La Tour deals with Anticipatory breach of contract. In which one of the following judgment a constitution bench of Supreme Court held that the sale and the installment of the lift is a work of contract? Cone Elevated India Limited versus State of Tamil Nadu. Lalman Sakra versus Gauri Dutt general offer. M. Pisson versus Apanna. Invitation to offer. Banwadi Lal versus Sudarshan Dayal. Intention to create legal relationship. MC Chaco versus Bank of Travancore. Privity of contract. Durga Prasad versus Baldev. Act was not done at the desire of promisor and hence no consideration. Al-Biddu Aziz versus Muslim Ali. Other party has done nothing in response to unilateral promise and hence no consideration. Dunto versus Pauli. The agreement was by enforced by the third person for whose benefit the agreement was made. Tweedle versus Atkinson. No stranger to the consideration can take advantage of the contract although made for his benefit. Balfour versus Balfour. Intention to contract. Feldhaus versus Bentley. Communication of acceptance of offer. Keller versus Henry. Frustration of contract. Harvey versus Fish. Invitation to receive offer. A statement of a price is not an offer. Harvey versus Fishy. Exception of the privity of contract. Khwaja Muhammad Khan versus Hussain Begum. Acceptance must be communicated to the offerer. Fetthaus versus Bentel. No estoppel against the minor. Mohri versus Dharmdas Ghosh. Lalman Sukla versus Gauri Dutt general offer. Tweedle versus Atkinson privity of contract. Balfour versus Balfour restitution. Khan Gul versus Laksin intention to contract. Invitation to offer. Henry versus Fincey. Anticipatory breach. Hoscher versus Dalatour. Restitution. Leslie R versus Limited Sally. Implied contract. Uptown Rural District versus Council Pauli. Satyabrat Ghosh versus Mangni Ram doctrine of frustration. Raja Rani versus Prem Adib miners agreement. Intros Limited versus Mile for East Corporation communication of acceptance. Hardware versus Fishy invitation to offer. Counter proposal. Head versus wrench. Damage for the bridge. AKAS Jamal versus Mullah Daud. Acceptance of conduct. Acceptance by conduct. Hindustan Co-op Insurance Society versus Syam Sundar. Commercial hardship. Ganga Sadan versus Ramchandra Ram Gopal. MG George versus MG George. Intention to contract. Wicks versus Tybalt. General proposal. Henderson versus Stevenson is naval notice. Cree versus Misa consideration. Handley versus Vexendale remoteness of damage. Gunrace Mosover versus Mosover indemnity. Dunlop Phematic Tire versus New George Motor Company Limited liquidated damage. Kinry versus Henry frustration. Doctrine of frustration. Taylor versus Cadwell special drug. Handel versus Accented anticipatory breach of contract. Hosters versus Dalatour crossover. Teen versus Hoffman and Company. General offer. Carlyle versus Carbolic Smoke Ball Company. Contract by telephonic communication. Bhagwan Das versus Girdhari Lal. Acceptance given by ignorance of proposal. Lalman Shukla versus Gauri Dutt. Remoteness of damage. Handel versus Baxendale. Food Corporation of India versus Ram Kesav Yadav. Consideration. Kedarnath Bhattacharya ji versus Gauri Muhammad. Offer and acceptance. K. Balikrishnan versus K. Kamalam. Capacity of minor to enter into contract. Satyabrat Ghosh versus Mangni Ram and Bangar and Company. Impossibility of performance. Trading with enemy. Nand Kishore versus Kunj Bihari Lal. Trafficking in public office. Gauridhan Singh versus Niradhar Singh. Interference with admission of justice. Expositive versus Bowden. Marriage blockage and contract. Sri Saran Lal Kesav versus Prasad. Remoteness of damage. Madras Railway Company versus Govind Rao. Proof of loss to be given to the claim of special damage. Chief Secretary versus State of Gujarat versus Kothari and Associate. Loss of profit is a special loss. Sadan H. Thakre versus Saran Engineering Company Limited. Consequence of delay and transit. Union of India versus Steel Stockholder. Mistake as to non-existence of subject matter. Gustave Contreras versus Robert Hasty. Big mistake as to the title of right. Bell versus Level Bros Limited. Different subject in the matter in mind. Raphael versus Winch Halls. Mistake as to the substance, nature and quality of subject matter. Sheikh Bros versus Limited Onshore. Proposal. Madras Rajya Sanskari Kapis Updan Pranam Mangna Bhang Chaudhary. Invitation to make an offer. Garis and Son Gong. Communication and acceptance of offer by acceptance himself. Hentrom Fisher. Revocation of offer. Polly versus Lee. Undue influence. Lansrine Loins versus Black. Misrepresentation. Nursing Spec versus Wig Company. Fraud. Direct versus Brick. Jagannath versus Secretary of State of India. Mistake. Lapse of offer. Lalman Shukla versus Gauri Dutt. General offer. Lapse of offer. Henton versus Fraser. General offer. Brick versus Tabby. Communication of proposal. Lalman Shukla versus Gauri Dutt. Implied proposal. Coffee. Borden versus OCT.